hit record. We're
This
going.
meeting is being recorded.
Claudia, go ahead.
All right, so I'm Claudia and I'm going to talk about the first couple slides. We're doing chapter 9, discrimination in employment. Oh, do I just, oh.
I got it.
Okay, so discrimination, one of the most extensive federal employment laws of Civil Rights Act of 1964. It provides in parts that it shall be unlawful employment practice for any employee, to fail or refuse to hire or to discharge any individual, otherwise to discriminate against any individual with respect to his terms and conditions of privileges of employment because of such individual's race, color, religion, sex, and national origin.
I'm Phil Jansen. I'm going to talk a little bit about this slide where it says the Supreme Court developed a 3-step procedure for Title VII challenges. This is referenced on page 225 in your text, and it kind of goes into some good detail that we'll talk about here on the next slide. The way I understood it, it's kind of like ping pong. It goes back and forth between the plaintiff and the defendant when there's a claim against discrimination in the workplace. It says, number one, the plaintiff carries the initial burden establishing prima facie case of employment discrimination. So prima facie stands for at first sight. So basically, the employee's evidence must be enough to allow a judge or a jury to infer that there's discrimination that took place. So kind of that first look, does it look like discrimination? So that judge and jury can kind of start to look at that case. And then number two, it says the burden shifts back to the defendant to refute the prima facie case by demonstrating that a legitimate non-discriminatory purpose forms the basis of its actions. So, once the employees met this burden of proof, now the employer must present evidence of a legitimate non-discriminatory motive for the employment decision at issue. So now the employer's kind of, given their side of the story, this is why we feel we were not discriminatory towards the plaintiff or towards the employee. So they're giving their side of the story. And we'll talk about a case here in a minute that kind of shows the back and forth between this. So then on the next slide, number 3 says if the defendant is successful in its contention, then the burden shifts back to the plaintiff to show that the defendant's actions were a mere, pretext for discrimination. So if the employee is able to provide some reasoning why it wasn't discrimination, now they're going to go back to the employee. Sorry, if the employer is able to provide some information why, or some evidence why it wasn't discrimination, now the employee is going to go back and, kind of in that back and forth, provide, this is why it was discrimination. So the employee has the opportunity to challenge that employer's evidence by showing, there was a decision where there's pretext for discrimination. And continuing on, it talks in the text on 225 about 2 leading non-educational cases. One is Donald Corporation versus Green Fernco, and then the construction corporate waters. It doesn't go into a whole lot of detail in the text about those cases, but it just notes that there are 2 leading non-educational cases.
Hey Phil, we could hardly hear you there. Can you kind of repeat that?
I'm sorry. There's 2 on page 225. It talks about these non-educational cases: Donald Douglas Corp versus Green and Fernco, and then Construction Corp versus Waters. There's not a lot of detail in the text about those cases, but there is an educational case that they talk about. Are you guys able to hear me better now?
It's kind of in and out.
I apologize. I don't know if there's something else I can do.
You stay right there, you're good.
Okay, I'll try that. Well, one of the cases they do go into detail in the text about is a case in Texas where there was 2 male bus drivers that went out drinking the night before work at a bar, and then the next day one of the bus drivers had his friend clock in for him at work. So he clocked in for him, and then later he decided he just wasn't going to come to work, so he called in sick. So during this case, the school, they decided that they were going to discharge both of the drivers for misconduct, both those male drivers. Well, the male drivers sued the school district because they said that it was gender discrimination because there's been female drivers in the past who have done the same thing. Well, and first they ruled against, or the court ruled for the bus drivers. Okay, they said that they were awarded lost wages and $175,000 for mental anguish. But then the state court of appeals, they affirmed that judgment, but then it went to the district court and the Supreme Court of Texas, and they found that even though the female employees that they said were clocking in for others, they didn't fail to miss work. And since they didn't fail to miss work, that decision was in reverse. So that's kind of that back and forth where it goes through that 3-step process and kind of gathers the information as much as possible. So since the female employees didn't fail to show up to work, it didn't, they didn't conspire to conceal their absence. They still showed up to work. And since they still showed up to work, they didn't think that those two cases were similar, that the female and the male employees were similarly situated, I guess. So they decided that the conduct of the females was not as serious. So the court reversed the judgment and held that the drivers should receive nothing. So they ended up not receiving anything for their claim against discrimination. So, and if the course of the defendant can demonstrate the absence of a discriminatory motive, there's no need for step 3. So sometimes you don't have to go to step 3 if, the defendant proves that there was no discrimination that took place.
Next, we'll jump into sexual discrimination. I'm Byron Dacey. We'll talk a little bit to start. Title VII was initiated in 1964, and then in 1972 it was amended to help education. It covers everything from sexual discrimination, age discrimination, and a number of other things. It also protects people from retaliation, employees from retaliation against from their employer because they have filed a discrimination charge against their employer, or it also includes those that participate in a discrimination hearing. So if they were a witness to it, or those who are opposed to the discrimination. It means that the employee, let's say they do win their discrimination case and they still retain their employment at that job. They can't be fired, they can't be demoted, they can't get a negative evaluation from their employer because they brought this suit onto the employer. So it's a good part of Title VII that really helps out the employee and protects them in cases where they do bring that against their employer. Another one it talked about, we'll talk about the sex discrimination. It's discrimination based on sex. The Title IX of the Education Amendments Act of 1972 prohibits sexual discrimination by public and private educational institutions receiving federal funds. That's the key term there is receiving federal funds. There are private institutions that do not receive any federal funds. And so they can kind of skate by on this a little bit. There's an interesting case that they were talking about with the private education because of the idea, the Individuals with Disabilities Act. There are students that will attend private schools where the public school is having to pay for them to go to those schools because the public school doesn't have the program that that student needed. In that case, that private school is now receiving federal funds. And so they fall under the Title IX, which I found was quite interesting. And I'm sure that there are some private schools that aren't aware of that when it initially happens. So Title IX is administered by the Office of Civil Rights for the Department of Education. Some more sexual discrimination things that was talked about in the book that aren't really covered here in the slides is transgender teachers. They said there at the time of this book was written, there's only about 30 in the entire country. And they talked about how the school should not treat them any differently than any other teacher or educator, and that there might need to be some training for parents and students about that teacher so that it's not such a shock or some uncomfortability for those people. And then another thing that was talked about is the Employment Non-Discrimination Act of 2013. It just prohibits discrimination on the basis of sexual orientation or gender identity. So it kind of goes along with that. And this year, the Title IX, Title VII, they make provisions for sexual distinctions in employment where sex is a bona fide occupational qualification. So. Sorry, one more thing, Jack, before I get to that. They also talked about unwed pregnant teachers, and they talked about how pregnancy is considered an illness and should be treated that way. So teachers that are pregnant and have a kid, that their time off should be treated as if it was sick leave. And there's also FMLA, which we'll get into later on. But I just found it interesting that they mentioned that because none of the court cases were after 1990 that they talked about there. And they also talked about like single mothers and how that kind of played a part. And I thought it was interesting how just with women's rights and how they kind of basically if they weren't married and they were having a kid, it was the courts would allow them to be removed because they didn't fit that stereotypical family. Like they were not fit to be a good example for students. So I just found that those couple interesting things there. So.
Okay, I am Jack Notes, and I'm going to talk a little bit about the Rehabilitation Act of 1973 and the ADA, Americans with Disabilities Act of 1990. You want to click the.
Yep, sorry.
So the Americans with Disabilities Act, in conjunction with the IDEA, protects individuals with disabilities against discrimination and assures equal access and opportunity. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination against any otherwise qualified person who has a disability with respect to employment, training, compensation, promotion, fringe benefits, and terms and conditions of employment. In the text, it says that the act states no otherwise qualified individual with handicap shall solely by reason of his or her handicap be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So basically, this just ensures that that these people with these qualified disabilities are protected under these programs that are receiving the federal funding. The ADA is similar to Section 504 and not only protects students with disabilities, but any person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded by others as having such an impairment. So kind of like what I just said, all these people with disabilities are protected under these programs. Major life activities as interpreted by the Act may include such tasks as caring for oneself, performing manual tasks, hearing, seeing, speaking, breathing, walking, learning, and working. So section 504 extends beyond the school. It took the ADA and it extended it beyond the school system, the school environment, and it protects all people in work programs as well that are receiving that federal funding. And I think it said in the slide already, but I just wanted to mention the fact that it requires that there's no discrimination against the individuals with disabilities. So these acts make sure that these people with disabilities are not be discriminated.
Qualifications of employment. Any individual with disability is qualified under the ADA if with or without reasonable accommodation, he or she can perform core functions of the employment position held or desired to be held. In the book, it refers back to that existing facilities must use employees and they must have, they must be accessible. Also, it talks about like job reconstructing, excuse me. It's like part-time and modified work schedules, reassignments, and kind of adjusting some of the workload to meet the employer's need. The scope of protection of section 504 and the ADA, both ADA and Rehabilitation Act impact public schools for prohibiting disability-based discrimination. When there is an allegation brought against the school district claiming discrimination, individuals bringing these charges may file a complaint with the Department of Education.
Racial discrimination starts off by saying the equal protection standards prohibited discrimination, which can be linked with a racially motivated objective. And we'll talk about a few cases here in a second. It says, unlike Title VII, no remedial action was attached to the Equal Protection Clause unless there was clear evidence that segregation was caused by de jure, official, and deliberate laws or policies to promote segregation. So on page 234 of our textbook, it brings up a case, Griggs versus the Duke Power Company. This one's not public school based, but it's important when it comes to this racial discrimination. Basically, you know, it was found that this power company was discriminating against African Americans on their hiring processes, and then they're, you know, moving up with promotions within the company. And they'd openly discriminated on the basis of race and hiring and assigning employees in its plants. So they found in favor of the plaintiff that, you know, this discrimination was taking place and the requirements weren't the same as they were for, you know, the African Americans. They were having them take these aptitude tests and things like that they had not made some of their white employees do in the past. So that was an important ruling in that case. And then another one mentioned on the next page on 235 does have to do with education. And it was the United States versus South Carolina. And the United States versus South Carolina, they were challenging South Carolina because they were requiring these national teacher examinations for certification purposes and also for you know, their salary criteria, their salary or what the teachers were making by these national teacher examinations. So the United States challenged it. African Americans historically were required scores resulting in discrimination, but it was found that they ruled in favor of South Carolina because it was a set score that they were required to get. So they didn't feel like that was discrimination because there was a score and it was a test that was proven to, you know, provide the qualifications for the teachers that they were hiring. So that's the case where discrimination, you know, was not proved to be taking place. It says Title VII involves two basic types of claims, disparate treatment and disparate impact that we'll get to on the following slides. The Supreme Court addressed these two important issues in a later case involving discrimination on disparate treatment and disparate impact. So the next slide talks about disparate treatment. It simply means that an employer treats some people more unfavorably than others regarding employment, job promotion, or employment conditions based on race, color, religion, sex, or national origin. So in the book, it talks about, I thought this case is kind of interesting. A teacher sued the superintendent and the other district officials for wrongful discharge based on racial discrimination and denial of free speech. Well, this teacher is actually Caucasian, but she was hired by the school district to oversee the district's gifted program. And she felt that there's difficulties with the school officials, including minorities with that gifted program. She didn't feel like maybe they were getting a fair shake. And because of that, the district officials told her that she was stirring up trouble and meeting with minority parents, advocating for changes in the gifted program. And that's why she was discharged from her job, because she was stirring up trouble. So they claim that she didn't understand the local culture. Okay, so the court held for the teacher by stating employees are entitled to protection from the retaliation for speaking out against racial discrimination, which she was doing based on that Civil Rights Act of 1964 and the First Amendment. So the court ruled in that teacher's favor after she was wrongfully discharged from her position. And then another case that they talked about was a teacher who sued the school for wrongful discharge again during her 3-year probationary period before she could gain tenure. The teacher was discharged after her 2nd year of her contract. So the teacher argued that the applicable law, precluded her discharge without valid reasons from the superintendent. That's quoted from the textbook. And the court held for the teacher there in that case as well that she was wrongfully discharged during that 3-year probationary period based on discrimination. So the implications of that court decision suggest that school districts were not allowed, will not be supported when their rules and policies discriminate based on race. So 2 pretty important cases that are referenced there on page 236. And then disparate impact is merely showing that a number of people of similar class are affected adversely by a particular employment practice, which appears neutral, such as requirements that all employees pass a test. So that kind of goes back to some of those earlier cases I talked about, the power company. They were, requiring their African American employees to pass the test, where not necessarily with their white employees. So that did show that disparate impact. But in the U.S. versus the state of South Carolina, everyone was required to pass the same test, and there was the same requirements for everyone. So the court ruled that there was, not disparate impact in that case.
So we'll jump into age discrimination next. And just kind of go back to Title VII and Title IX, if you're interested in kind of a summary of both of those acts and what goes into them, page 230 of your book talks about both of those, has a great breakdown of both for you there. So age discrimination in public schools primarily affects teachers. In the past years, many districts have forced teachers to retire when they have reached a specific age. These policies and practices are challenged by the teachers under the equal protection guarantees. So it's the age discrimination. It's kind of, you hit your age of retirement and they try to force you out. It happens with when there's a RIF. It happens a lot with that, where the district doesn't have money and they have to cut some positions. Well, if they cut the teachers that are older, who are probably making more money, they can then come back in and save money there. And then when they go to rehire, they're hoping that those teachers will just retire and then they will just hire somebody new and young who they can get in for much cheaper. And the book there was a case that the book talked about where that did happen, and the teacher, the older teacher that was at the age of retirement was riffed, and like 2 months later they hired a new person into their job because they found more money, and so they sued the district and were able to actually get their job back. All challenges and uncertainties become insignificant with the passage of the Age Discrimination in Employment Act of 1967. The age there was 65, and then when it was amended in 78, the age went up to 70. And then it was amended actually again in 1986, and there was no age limit set with that. Like I said, the amendment in 1986 removed that limit completely for persons in certain public safety positions, except for those like police officers, firefighters, where if they do get to be too old, their ability to do their job is then impacted. And it talked about how this does cover teachers and other public employees. It does talk about how age cannot be the sole reason for you to be let go from your job. So, and then pregnancy and public school employment. Teachers in public schools are protected by the Pregnancy Discrimination Act of 1978. The law, it's an amendment to Title VII, which extends protection to pregnant employees. Basically, you cannot be fired for being pregnant, is what that comes down to. You can't have your job diminished, can't get a demotion, you can't have your hours cut because you have become pregnant. Court's been fairly consistent with this, and regarding issues that are related to pregnancy. So they tend to stand behind those employees that are pregnant.
So I'm going to talk a little bit about sexual harassment in the workplace. You know, pull up
Yep,
those
sorry.
points. Sexual harassment is prohibited by Title VII and Title IX. It was not included in Title VII of the Civil Rights in 1964 until 1980. So sexual harassment was not in there till 1980. Its primary intent is to protect employees from harassment in the work environment. So harassment is considered to be a form of sex discrimination. It can manifest itself in many forms, from verbal statements, gestures, or overt behavior. The victim, as well as the harasser, may be male or female, not necessarily of the opposite sex. So the text said, or gave some examples or different forms of harassment. I'll just name a couple. Offering sexual comments regarding a person's anatomy or clothing, requesting dates repeatedly and refusing to accept no as an answer. And then some nonverbal things were prolonged staring at a person, presenting personal gifts without cause, throwing kisses or licking your lips at somebody, making various sexual gestures with your hands, or even posting sexually suggestive pictures or cartoons. So basically, harassment comes in many forms, verbal and nonverbal. And then that, not necessarily of the opposite sex harassment. There was a case, Onkale versus Sundowner Offshore Services, and that is actually where the Supreme Court held that same-sex harassment is illegal and a violation of Title IX. More serious levels may involve sexual coercion or unwanted physical relations. This type of behavior, quid pro quo, is commonly associated with superior subordinate relationships where the victim, for fear of reprisal, will unwillingly participate. So real quick, quid pro quo means basically giving one thing of value in exchange for something else. So it said is associated with superior subordinate relationships, basically meaning that there's a person in control or a person with power who has the ability to refuse to hire, refuse promotion, deny certain privileges, stuff like that based on their position. So in many instances, the victim will be promised some sort of benefit that is job related in exchange for sexual favors. So that's what that part is saying. I see we only have about 2.5 minutes. That's all I have. Does anyone else have anything? Okay.
I think that's
That
it.
was chapter 9. Thank you for watching.